Amazing. Right, welcome back to the Licensing Subcommittee on Tuesday the 3rd of June 2025. In this case, the subcommittee has had to consider whether a private hire driver remains a fit and proper person in accordance with the Section 51 of the Local Government Miscellaneous Provisions Act 1976, and accordingly whether action ought to be taken under Section 61 of the same Act. It is noted that the driver has a conviction dated the 12th December 2021 for the use of a mobile phone whilst driving, resulting in 6 penalty points and a fine of £200. It was disclosed by the driver shortly after, January 2022, to the Licensing Department. He was asked to supply evidence of the conviction, as it was not showing on his DVLA summary at that time. Whilst the detail was passed to the operator, it was not provided to the authority. The subcommittee heard that this was an isolated incident and the offence was admitted at the time. However, he had a passenger that had been sick in the vehicle and could not pay the fare and soiling charge. She had telephoned her mother and asked the driver to speak with her mother, which he did when the phone was placed on the centre console and on speakerphone mode. The phone had initially been pushed to his ear by the passenger. It was noted by the subcommittee that this application, particularly that he did not hold the phone, amounts to what would have been a defence to the offence. The subcommittee was referred to paragraph 6.8 of the report and paragraph 1.6 of the current policy at chapter 8, which states the committee cannot go behind or review the merits of previous criminal convictions. Driving a taxi or private hire vehicle is a position of considerable trust and responsibility. The subcommittee was referred to the Portsmouth City Council policy referenced in the report, which indicates that a conviction for using a handheld device whilst driving means that an application should not be granted until at least 5 years from the date of conviction and will ordinarily lead to revocation of licence. Further, the subcommittee was referred to the policy, which states that the function of licensing is as set out in the case of McCall v Rushcliffe Borough Council. The objectives of the licensing regime are plainly intended, among other things, to ensure as far as possible that those licensed to drive private hire vehicles are suitable persons to do so. Namely, that they are safe drivers with a good driving records and adequate experience, sober, mentally and physically fit, honest, and not persons who would take advantage of their employment to abuse or assault passengers. It was stressed that the personal circumstances, including the financial position of the driver, are not generally relevant when considering suitability to hold a licence in accordance with the case of Leeds City Council v Hussein. The subcommittee was also referred to the modern interpretation of the fit and proper persons test set out in the statutory standards document. Without prejudice and based on the information before you, would you allow a person for whom you care, regardless of their condition, to travel alone in a vehicle driven by this person at any time of day or night? If, on the balance of probabilities, the answer to the question is no, the individual should not hold a licence. The subcommittee considered carefully the driver's accounts of events, that this is an isolated incident with no other complaints in his driving experience since January 2017, and the policy is strict in its approach. However, there has been considerable delay in bringing this matter to the committee, to the extent that the penalty points have fallen away from the driver's DVLA driving licence, and the endorsement will only be on the licence for a short while. The driver has, as a result, been able to continue to drive for a period of nearly 3.5 years since the conviction. In this respect, and due to the administration error, this case is considered an exceptional and highly unusual set of circumstances. It was clear that the driver had been honest in his approach to the conviction and at the time of the offence had acted in the best interests of a vulnerable person, despite the mess and inconvenience. In normal circumstances, the conviction would lead to a revocation of the licence, but in the light of the lack of issue before or after the incident, the driving record generally, the frankness and openness of the driver, and the actions to help and protect a vulnerable passenger, the subcommittee has determined that this is an exceptional case which justifies departure from the policy. Having considered all of the above, including all the relevant facts, having applied the strict policy wording, statutory standards, the conviction, which must be accepted on its face, and the relevant case law, the subcommittee is satisfied on the balance of probabilities that the driver remains fit and proper in accordance with the legislation at this time. In reaching this decision, the subcommittee has had regard to the driver's human rights and is mindful that the decisions must be made reasonably, proportionately, and in the public interest. Promoting public safety is at the heart of this decision. This is a serious matter and the driver should be warned that any further issue of concern without prejudging may lead to revocation of the licence. The driver is strongly advised to make sure he is fully aware of all the obligations set out within the licence and conditions attached to it. There is right of appeal against this decision to the Magistrates' Court, which must be lodged within 21 days of formal notification. So to summarise, you're all good. You get it back. You're allowed it. Okay? And that ends today's subcommittee. You're very welcome.